Hi, everyone. This is Sam Silverman, Managing Partner of EB-5 Thank you for taking time to join us on today's webinar. Today, we're going to be speaking about concurrent filing for EB-5 visa investors, and we'll be speaking with Seema Mehta on this important topic that impacts many, many investors who are investing post-RIA after March of 2022. Okay, here's a quick overview of the 5 major topics that we're going to be speaking about today. We'll chat a little bit about EB-5 We'll talk about Seema Mehta and her firm. We'll discuss concurrent filing. We'll talk about what categories of investors are eligible for concurrent filing. And then we'll chat about some considerations to reduce immigration risk with respect to doing EB-5 and concurrent filing as well. So a little bit about EB-5 We're a leading EB-5 investment fund manager. We oversee regional centers that cover most of the United States. We worked on many, many projects over the last 11 years. This is a map showing where many of our investors have come from over the years. We've worked with more than 2,000 investors from more than 60 different countries. One of the things that makes us unique in this space is that we have regional centers that cover the entire continental United States, which gives us great flexibility in seeking out the most compelling and the most attractive rural and urban TEA EB-5 projects around the United States. As I mentioned earlier, I'm Sam Silverman, one of the 2 managing partners at EB-5 A little bit more about my background and bio is there on the left side. And my partner Mike Schoenfeld there on the right side. Today we have the pleasure of having Seema Mehta, the founder, managing partner of the law offices of Seema Mehta with us. And I will let Seema jump in and share a little bit about her experience practicing as an immigration attorney. She's one of the most well-respected EB-5 immigration attorneys in the space and has worked with hundreds of EB-5 investors over the years.
Yes, hi Sam, how are you?
Good. Thank you, Seema, for taking time to join us today.
I did want to correct that we've worked with thousands of investors. We are an immigration law firm based out of Dallas, Texas, and we primarily work with investors from all over the world and have been doing it for over 20 years now. We do take care of other investment and employment-based visa categories, but EB-5 investors are our primary focus.
Perfect. Thank you. And excuse me, I didn't realize it was quite that many, but yes. That's very, very impressive. So on today's webinar, EB-5 is a very complicated investment. There's a lot of steps to the immigration process, so we're not going to unfortunately be able to cover every aspect of the process, but we are going to spend most of our time today discussing concurrent filing, which is a new aspect that's come into play post RIA, so post March of 2022, and that's where we'll spend most of our time, since that's particularly important and a major new benefit for investors who are already in the United States, who are considering making an EB-5 investment. So maybe to start with, Seema, could you tell us just what is concurrent filing and what are the benefits of it, and then kind of who's able to take advantage of it?
Definitely. Concurrent filing essentially, in simple terms, just means that we file our baseline petition, the immigrant petition, as well as the adjustment of status application together, concurrently. That happens when any visa category is current on a visa bulletin, which essentially in layman terms means that the visas are available in that category to file adjustment of status. Post RIA, since March of 2022, USCIS has made the rural categories, urban TEAs, I think all the categories are current for all nationalities, but we cover a lot of Indians, and this category is current for Indians as well. So concurrent filing is of a huge benefit to a lot of investors filing their I-526 petitions at the current time.
Got it. So my understanding, so if an investor, let's say, an Indian investor who's, let's say working for Apple, living in the Bay Area, and since India is current on the visa bulletin, let's say that investor picks a project, let's say they want a rural project, they invest, and then after they've invested, then what do you do after that? What is the investor, filing with you?
I did notice that you added the term when an Indian investor invests in a rural project. I did want to add in that the government, USCIS, promised and has kept its promise that they will prioritize the processing for investors who invest in rural areas specifically. So they will process and adjudicate the petitions faster. So if a person is in the United States on any non-immigrant visa, valid non-immigrant visa, which could be so many different categories, we can come to that later, they are eligible to file their I-526, which is the baseline petition, and their applications for adjustment of status together. When you file these applications together, in my opinion and in what I have seen, when you do a concurrent filing, the whole package, the whole petition package is streamlined. It is processed faster, processed better, because your I-526 and your I-485 are immediately linked. Now, the second advantage is that when we file adjustment of status, we are eligible to file for a request for employment authorization, which allows an individual to work anywhere or not work at all. We are also eligible to apply for which is a travel authorization, which allows an individual to travel anywhere for around 1 year. When you have an advance parole, you're allowed to travel out for 1 year and be back within the 1 year time frame. So which are two huge benefits that any investor can get immediately. And by immediately, I mean around 3 to 4 months of filing.
Got it. Okay, so going back to that example of the Indian investor working for Apple, let's say that investor invested in a rural project, they're working with you, they've invested the funds, now you file for the adjustment of status, you file the I-526E, and you apply for their EAD and their advanced parole travel document, at that moment that those documents have been filed, can the investor quit his job at Apple and stay in the US legally, or do they have to keep working at Apple until, this EAD and advanced parole get approved in a few months?
They can quit their job if they wanted to. They cannot take another job until the employment authorization is approved. Quitting the job will not matter at this point. Say someone was on an L1 or an H1B. These are all employment categories where a lot of individuals are here working on. And they were to stop working for that particular employer who was the petitioner on their H1B or their L1. They can now stop working as soon as they get their receipt for I-485 and then wait for the employment authorization document to be approved. And then once that comes through, they can start working for any other employer, start their own business, or stop working altogether. So huge benefit. And then to add, if it is a rural project and with the promise of expedited processing, we are seeing, and I'm sure you are seeing a lot of that too, that the EADs and APs are getting approved in as early as we've had a client whose EAD was approved in 49 days to about 3 months to 4 months. We see that the USCIS is approving the EAD document, the authorization.
Okay, so just a few months. So very, very fast.
Mhm.
And what, you mentioned earlier the prioritized processing for investors who select these rural TEA projects.
Mhm.
What have you seen in the last 2 years in terms of approval, timings for investors who've chosen the rural projects? Like how long is it taking to get the approval for the temporary green card?
The temporary green card, with our offices, we've not received the 485s yet. We are hoping to get a few very soon. I think because we began filing for these in September of 2022. We were not the earliest. But we've seen I-526s being approved within 9.5 to 10 months. The earliest has been 9.5 months. And then within 10 months, we are seeing quite a few coming through, as long as we've invested in rural projects, though. And
Got it. Got it. And
I'm sorry.
would you would you say that, of all the clients that you've worked with since the RIA,
Uh-huh.
since the new rural category was created, what percentage of your clients have chosen to do the rural projects versus the urban projects?
Post RIA, most of our clients have been people who are on H-1Bs or L-1s or E-2s who are already in the United States. And I've seen that almost 60 to 70% have opted for rural projects just because of this expedited processing and because the number of visas available are almost double of the urban TEAs. So
Yep.
there is
And
a psychological benefit also. It kind of makes you feel that you have a larger number of visas available. And of course, the prioritizing of processing and adjudications by USCIS is of a great help.
yep. So let's talk a little bit more about that. We talked about the priority processing,
Uh-huh.
which is really the speed of which the government is going to review the I-5 to 60 application itself, which is kind of the first step. But then what is this 20% set aside visas, and why does that matter? Why is that important?
So every year there is a set number of visas assigned for EB-5 investors. And if there were 10 visas aside, 20% of the 10 have been assigned for rural projects. And then 10% have been assigned for urban TEAs. So I'm just trying to take the number 10 because it makes it easier. So if there is one visa for an urban TEA, there are two visas for rural TEAs out of the 10 that are available to us.
Got it. Okay. So basically having more visas available means that, you know, you're more likely to obtain the actual green card quickly after
Mhm.
your I-5 to 60 is approved, because there's going to be more visas, which means that it's more likely that your country will be current,
Yeah,
essentially.
definitely.
Got it. Okay. And I know that, a lot of the H-1B clients, a huge reason why they're looking seriously at EB-5 is because the category that they're in, as H-1B, L-1, is very backlogged, and there aren't enough visas, right? There's a major shortage there, and so, they're not, they're very sensitive to doing an application in another category where, they could face a similar shortage of visas.
Definitely, definitely. That is a huge concern. It's a huge concern, and because we are seeing so many of the H-1Bs and L-1s or any non-immigrant category, when they come and work in the United States, their route towards getting permanent residency are these employment-based categories. And for Indians and Chinese, these are quite backlogged. So the investor petitions become a very attractive option for a lot of them. Because of this, especially now because it is under the current categories.
Right. And so let's just take a quick look at this most recent visa bulletin for April. Can you kind of walk us through, the last 4 lines, the last 4 rows of this table, and then also, maybe spend a minute or two on some of the earlier rows for the first, second, third categories, so you can kind of see how that contrasts with the dates for India.
Okay, are we talking specifically about India? Let's talk of India then. For India, all the people, we are talking of the first few categories now, the EB-1, EB-2, EB-3, which are all employment-based categories, EB-4. So the problem here is that the number of visas versus the number of applicants, there is a huge disparity. We have 10 visas and 100 applicants. And it becomes, that's why we are seeing a huge backlog in these categories. These categories, the people who have filed their petition, when you look at India and you say, let's go to EB-1. EB-1 is a specialized category. Not everyone who's on H-1B can file an EB-1 because it is exceptional ability or special ability category where you've got to establish, say, a physician or a PhD or a IT professional with a lot of experience. They qualify under that category, and that is also at a 4-year backlog, at least 3 years for now. And it seems to be going a little longer as we look ahead when we start calculating the dates as they keep appearing every month. It seems that it's going to go to 4 years soon. So you file it today and you've got to wait for 4 to 5 years before you are even eligible to file for adjustment. The category needs to say, it has to show C that is current on this visa bulletin to be able to file for adjustment of status and the benefits that come along, the EAD and AP. So, and then moving on to the categories going further, EB-2, EB-3, which is most of the people, you can see the dates are April 2012. So people who have filed the baseline petitions, which are generally the I-140s, these categories, the people who were approved on these dates in 2012 are able to file on 15th April 2012 are able to file for adjustment of status now. So people who have a date of, say, 14th April 2012 cannot file for adjustment now. And are they able to file next month? No, they're not. The visa bulletin is moving very, very slowly. Each month we wait for it to at least jump a month, but that is not happening. We are seeing these dates stagnate, just sitting there and not moving, which is what gives an uncertainty to most of these people who've been here for so many years, working, employed at good jobs, and their children, all children growing up, they can file for their children with them until the child is, say, 21. After that, they cannot apply in the child. I mean, there are multiple problems related to filing adjustment of status based on these categories. And then you roll down, and then you see the last 4 rows, and you see this, the top one, which is the direct investors. When by direct investors, all I mean is that they can invest anywhere. They don't need to look at high unemployment areas, or they don't need to look at the urban areas, rural areas. They can just start a business at any place, and they can file for their I-527 petition. But those categories are also backlogged by a few years. You see 4 years backlog right now. So people, if you find a business somewhere, I have a lot of people who call me that we'll set up a business, say in Dallas. I tell them that we can do that, but because it is not a rural area, it is not a high unemployment area, we cannot do concurrent filing. We have to wait for this date, this little red section to be current, and then we'll be able to file. So we'll have to wait for 4 years, and then we'll be able to file. On the contrary, when we go down and we see the rural, and we see the set-asides for high unemployment and the infrastructure projects, you see the CCC, which means the category is current, which in essence means that visas are available for these people. They can apply for adjustment of status, and the government will process an adjudicate and give them their EADs and APs if filed together. So that's what this little table means.
Got it. Got it. Okay. And why, why doesn't the table move kind of in a linear fashion? Like if we go back up to the top where we see employment based and we look at the second category there, it says 15th April 2012.
Right.
We're almost at that exact date in 2024, but you're saying it's not going to take exactly 12 years for that person for that to become current. And why is that?
As I said, we have N number of visas assigned to a particular category to be assigned every year. The government will issue, I keep taking examples of round numbers. Say the government wants to give you 100 visas per year. We have 1,000 applicants per year. So we have, and the visas, when the government assigns visas every year, 140,000, I won't get into the numbers, but the government assigns a set number of visas, and then these visas are divided by the country. Every country gets 7% of the total visas in a particular category. So if there is employment-based visas, 100 visas have been given out, 7% will go to each country. The visas that are unused will fall to the countries which need more visas. And yet, countries like China and India, just because of our population and the large numbers that do the filings, we always consume the visas and need much more. And this has had a snowball effect for many years now. And each year there are more and more filings, while the filings of that particular year have not been fulfilled. So the 100 visas that were filed in, say, this year were not filled, but next year we'll have another 100. So it has had a huge snowball effect. And now we have hundreds of thousands of people waiting in the EB2, EB3 categories, EB4 category too. All these categories have a large number of people waiting, but the visas are not available. So slow and steady, as the visas get available each year, they assign it to the first in and first out. It's first in, first out with the USCIS. So as the dates become current, you are able to file. So if you're seeing the 2012 right now, again, it sounds ridiculous, but by the calculation, it is many, many years for people who filed in, say, 2013 to be able to see a current category on this little chart that State Department publishes every month.
Got it. Okay, so let's say someone applied from India today in EB2, and that's basically 12 years from where it's listed here, as being the current date. But basically, you're saying even though it's exactly 12 years later, it's going to take way longer than 12 years for someone filing today to become current, essentially.
When Sam, it will sound ridiculous, but when we do the proper calculations with the numbers given, it shows a very, very long wait time. I don't even want to mention how long. It's a very long wait time for people who would file today, and which is a really depressing thought, quite a depressing thought for a lot of people who are students, who come in here on F1 visas, spending a lot of money coming here to get a degree, hoping to be able to, get employed here and then become a permanent resident and a citizen of the country.
Yep. So let's talk a little bit about what are the visas that you see that are the most common and the eligible ones to adjust status. Let's say you're doing EB-5. We know all the categories are current. We've looked at the most recent visa bulletin. But from what kind of underlying visa can you start with and then be able to do an adjustment? And which of these do you see as kind of most to least common?
The most common that I'm seeing these days is the H-1B. I should actually say both F1s and H-1Bs. F1s are the students. F1 visa is for the students who come from overseas to do their bachelor's or master's here. And as you can imagine, most of them are already 20 when they come here on F1. So there are all these individuals who are hoping to join the job market and then the permanent residency here. H1s are employment-based visas which are given to all over the world. People coming here to be employed in specialty occupations, the ones who hold good degrees. We also see a lot of L1s. L1s are intra-company transfers for multinational organizations or any businesses which are in other countries which establish their offices here and transfer their employees. So these are the H1s and L1s are the employment-based visas. I'm taking the example of H1 and L1s first. These guys, these two categories are dual intent, meaning when they get the visa, the government gives them the benefit of stating that when they come in, they can decide to become permanent residents. So there are a lot of different kind of non-immigrant visas available. And a lot of people come on different non-immigrant visas to the United States. Out of all of them, the categories of H and L visas, which are employment-based categories, they have the benefit where they say we have the dual intent. We could want to stay back in the United States as permanent residents. So for them to be here and find, say, the investor petitions and file has huge benefit. They can file anytime and they can take the benefit of getting an EAD, NAP, and with the EAD start working anywhere or not work or start their own businesses. Whereas the other visa categories, the most common you would see would be the F1, which are the students. E2s, a lot of nationalities can file the E2 visas. These are the countries which have treaties with the United States, and they are allowed to send their citizens here to do businesses. So the E2, like F1s, the government does not allow dual intent. They give a promise that we are just going to the United States to, say, set up a business or to, say, just study. But then once a person comes to the US, many times it happens that they want to stay back. They do like the country. They do like we know that it is a great country to live in, raise your children. So they can change their intent, and the government understands that also. That once a person comes in, they can change their mind. They could be changed circumstances, just the thought process can change, and they can file also. So we see a lot of E2s from various nationalities. We see F1s from all over the world who file for investor petitions, because that seems to be a more they can move with confidence that they will get their permanent residency as long as they have a good source of funds and a good project to invest in. I can also touch on a lot of visitors when they come to the United States. Once they come in, of course, when someone comes to visit, they come in with the intent of visiting. But sometimes when they want to study here and stay back. They find a huge opportunity where they feel, oh, well, we can set up a business. They see a great job opportunity, and they can change their mind and say, okay, we want to stay. For them too, it is equally easy to file the I-526 concurrently with their adjustment of status. They do have different requirements. We can go over that in a different session. But yeah, they too can file for it. And the intent issues are, the government does look at the visa categories where they don't have dual intent. We have to explain why things changed, why someone entered, why an E2, he just set up his business, why does he now want to become a permanent resident, which could have multitude of reasons: a better lifestyle, a better future for the children, better business opportunities. So all these categories we see filing for immigrant petitions, the investor immigrant petitions.
Got it. And we just went over some of these details. I guess maybe spend a couple minutes and just kind of walk us through how you work with clients. it seems like most of them are in, the F1 bucket or the H1B. So maybe let's focus on those two. Yeah, how do you advise the clients? What does that process look like? The source of funds piece. What does that whole process look like, and how do you manage that, working with the investor and family members who may be involved in providing some of the funding too?
Right. Let's go to the F funds first then, because we are planning to chat with the F1 populace and the H1B. The F1s, as I said, are the students. Students, more often than not, won't have their own funding. Most of these students have their parents overseas, and their funds come from overseas. We have students from all over the world. My practice has a majority coming from Asia. A lot of them from India, Pakistan, Bangladesh, Nepal, Middle East, Far East. And for them, the funds generally come from overseas. So we work with their parents to see what their source of funds are. The source of funds need to be from a legitimate source. As long as the source of funds is clean, you have earned your money. It's not fruit of a poisonous tree, as we call it. The funds need to be clean, earned from a business or employment. As long as we can show the path of funds, as in how we earned it, how we collected it, did we put it in stocks, did we buy say real estate and sell it. So various different prongs to it of how the funds were acquired and then maybe invested and then reacquired for this investment. So we go through step by step with the clients in advising how we can work with their source of funds, and then how we can work with the rules and regulations of their home country to transfer the funds to the United States and to the regional centers wherever they wish to invest in. H1Bs are people who are already in the United States. So by and large, we are seeing that H1Bs have their source of income is their earnings in the United States. I find them fairly simple because they show their tax returns, their W-2s, that they're working with this organization. This is their salary, how they've made their money in, say, last 5 to 7 to 10 years, and then invested in stocks or 401ks or purchased land or a home. And then they regroup this fund to be investing in whichever project they pick up. For that regrouping, again, we advise them as to whether they can maybe sell a 401k, take a home from their 401k, sell their stocks, sell their land, sell a home, take a home equity loan on any property that they have purchased. And then we, again, pool all these funds together, and then it is invested in a regional center and a project of their choice.
And I guess, having worked with thousands of clients over the years, obviously, your approach and experience has really resonated with clients from around the world. What would you say, kind of sets you apart from a lot of the other immigration attorneys, who may not have as much experience with EB-5 and, may not have country-specific experience? Why should someone, bringing funds from India, for example, or an H-1B, who's from India but has been working in the U.S., why should they, work with you as opposed to some other, EB-5 attorney that maybe just doesn't have as much experience?
Of course, you're using the word experience. Experience definitely matters. We have so many years behind our belt doing EB-5, so we know what USCIS wants, how we need to present a case. We have, with the grace of God, we don't have any negative experience thus far. It has been a great ride, and what sets us apart is that we are a boutique law firm. We call ourselves a boutique law firm because we pay personal attention. Our accessibility is very, very, compared to most law firms, they are very accessible. We have a direct contact for all our clients to our office where they can immediately, almost 24/7, ask their questions. Very hands-on approach, very personalized. We try not to get emotionally attached to every petition, but it happens. We are, we have a very good team. Everyone is quite focused on EB-5. Everyone has learned the ropes of EB-5. It is a very complicated and equally simple process, right? It's complicated because we've got to ensure that we are completely aligned with what USCIS wants. We don't want the USCIS officer to be frowning upon each condition, each situation that we are trying to explain. Simple, because by now we know what precisely we need. So the client does not find it complicated. Once we start talking to them, we explain what we need from them precisely. As long as they give us that, they have nothing to worry about. We let them sit and relax while we do all the work.
Got it. And how long does that process typically take? Once a client decides, okay, I'm tired of waiting in this H-1B line. I really want to get the work permit. I've got an idea for a business. I want to, change my status. I want to take a break and then start something myself. They call your office. They want to get started. How long does that typically take? And, what documents are they going to need to provide? And, are you going to be meeting with them on Zoom every week, or are they going to fly and meet you or mail you documents, or how does that whole kind of application process look?
Well, once we chat, we generally have an initial Zoom conference with our clients just to get to know each other, to find out about their source of funds and what their goals are. After that, we generally give them access to a WhatsApp number. One paralegal, if they need to talk to me, they can talk to me, they can talk to other attorneys, and we collect documents only online. They don't need to mail anything. We've had clients who will fly from overseas, from other cities, just because they want to come and they want to physically meet you. We definitely don't need that. Once we talk to someone on Zoom, we are good. The timelines are basically the delays or the number of days that we need to file a petition generally depends on the client. And what averagely we see is, after we chat with the client, and if they are interested in pursuing the investor petition, then it generally takes about, from the first day to the filing, we take about 2 months. And that 2 months is primarily for the client. For my office, we take about maybe 10 working days to prepare the entire petition, assist them with reviewing all the documents, preparing the petition, the forms, getting it signed, and then talking to the regional centers, getting documentations from there, or in direct petitions, where if the investor is doing a direct, then preparing all the documentation. It's generally 10 days for our office, and then the rest of the time, almost month plus some, for the clients to collect documentation and give it to us.
Got it. And obviously, a big piece of the application is the project, the regional center project that the client is going to invest in. And so how do you kind of advise clients, generally, from an immigration perspective, what are the requirements of the EB-5 program, and how do we make sure that, at least from an immigration perspective, that the client's going to have a successful outcome? How do you kind of help the clients who haven't, maybe done a lot of investing, let's say in the US, or aren't familiar with the EB-5, program requirements, to make it all the way through the process? What are some of the suggestions that you have, that you share with potential investors?
The most important thing here for all the clients to remember is nobody can see the future, right? The regional center, the project, of course, see their future. They have outlined something for themselves, as in say EB-5AN and their projects. You know what you're aiming for, but we don't know the future. We only see what you are telling us. Any project will tell us what they are planning. What I look at in a project is whether they are doing everything that the USCIS requires, whether all their documentations are again aligned with the USCIS requirements. That is the baseline thing we have to see, whether the project seems eligible to qualify as an EB-5 investment. lots of regional centers now in the market, lots of projects. We've got to also see their past performance. We've got to see how they have done with their prior projects, because while we cannot see the future, we can definitely see what they have done with the projects that have finished. Whether the USCIS had any problems with them, how did they provide support to the client and the attorneys? Were they good? Were they giving the support that we needed? And then, of course, whether they completed as they promised, and whether
Yep.
they refunded the investment amounts as they promised also. We have seen in the past, of course, RIA has changed things, because now the government says that the funds need to remain for 2 years in some. Earlier, because the experience of return of funds has been only pre-RIA. Post-RIA, we don't have any of that experience, but we do know the regional centers. We do know their records, and we do know their ethics, how they work with clients. And then it becomes easy to suggest regional center or projects to the clients. And then when the clients request us, we do review all the documents. We do advise them whether this or that looks legitimate or not. And of course, when we have regional centers that we've worked with and we've seen their past performance, we've seen how they've dealt with us and our clients, we have more confidence with them, definitely.
Got it. Got it. Okay, perfect. All right, so I think we'll just spend a couple minutes, and I'll just provide a quick overview of a couple of our current rural and urban TEA projects that are available now, and then we'll have just a couple of concluding thoughts.
Sure.
So as a quick overview, so we have currently 5 different EB-5 projects open for investment. 3 of them are under the rural category in the first row here, which again, as Seema discussed earlier, means that investors qualify for the faster priority processing of the I-526C petition, and also have access to a greater 20% set aside of reserved visas, which means you're less likely to face any type of future delay in obtaining a green card. So first, our Twin Lakes, Georgia project. That's one where Seema was able to visit recently, which was great. This is a project outside of Atlanta, Georgia, being developed by the Coulter Group. They're one of the largest developers in the Southeast. They've been developing since 1997. This particular project has about 1,300 homes, over 600 already sold, almost 500 already completed and delivered to buyers, over 3,000 jobs already created, and several of our prior funds already have approvals. Second project here in the middle is our Kindred Resort at Keystone project. This is a condominium and luxury hotel project. It's in a prime location directly adjacent to the main gondola at the Keystone Ski Resort, which is managed by Vail in the United States, just about an hour or so outside of Denver. Most of the condos are already sold, and the project's already created enough jobs for all the EB-5 investors there. And the third project is our Walhalla, Utah project. This one is also a loan project. It's a secured loan with multiple mortgages on the property, almost 700 jobs already created, and we already have quite a few approvals in this project as well. And then shifting gears below, this is one development. It's a 210-unit multifamily apartment project, also being developed by the Coulter Group in Boynton Beach, Florida. This project has 2 different offerings. So one is an equity offering with a higher 5% annual return, and then the other one is kind of the more traditional loan structure with a shorter loan term of just 3 years with a one-year optional extension. So for investors who are more interested in a shorter target investment period and a higher return, but who are okay with waiting a bit longer to obtain the temporary green card, the urban projects, Boynton Beach Equity and Multifamily, and then the loan project are going to be kind of more aligned with that preference, whereas investors who want to obtain the green card as quickly as possible, the rural projects are going to be the best fit. It is important to note, as Seema mentioned earlier in the presentation, that investors can adjust status and obtain the work and travel permits the same in both urban and rural, because everything is still current. And so the main difference is just the timing of getting the temporary green card and the targeted return of the funds based on the structure of the investment. So those are important kind of differentiated points to note. And it's really going to depend on the investor's personal situation and the requirements of the capital and what the preferences are. All right. So I think that's a good summary there. Seema, I think to kind of conclude, if you could share kind of your top 3 or 4 general tips for investors who are have kind of heard about EB-5, they've maybe looked at it a few years ago, now maybe their stock options are up, they have more money, their home value's up. Now EB-5 is a little more expensive. It's $800,000 instead of $500,000. Why is now a compelling time for investors, particularly those who qualify for the adjustment of status? Why is it a good time to really look seriously at EB-5 now, versus waiting another 5 years, to see what may happen with a program in the future? What makes today kind of a compelling time to really consider making an EB-5 investment?
Before I go to the tips, Sam, I did want to add that all these timelines that we are discussing we were focused on Indian investors. If you're not from India or China, you really don't need to worry about whether you're investing in a TEA or a rural project. Your visas are available. You will file your adjustment. You'll get your EAD-AP and your permanent residency in time. Now, going back to the Indian investors, if you're here on H-1B and you have been thinking, or if you're sitting anywhere in the world and your child is here on F-1, you have this huge stress on your mind about the timelines of regular employment-based visas or family petitions, which are also backlogged a lot. We did not delve into that because immigration is just so vast that a half an hour the webinar cannot touch on all topics. So if you are looking at those horrendously long timelines, and you wish to pursue, say, a different job, or you want the stress of not getting your permanent residency for a long period out of the way, then you definitely need to look into the investor petition. The investor petition, as long as, of course, you're financially capable to do so, is a smooth route. I see a lot of concern whether we are going to get our funds back, whether we are going to get the permanent residency. Definitely. In so many years, I've not seen where a regional center is out to get your money. Everyone is trying to benefit each other. This is a mutually beneficial situation. The regional center definitely hopes to finish their project and give your funds back as promised. And in return, you are getting your employment authorization to be able to work, start a business, not work, go back to your home country for 9 months and do nothing, travel on your advanced parole authorization. So, it gives you a lot of freedom. If your children are aging out, that's another issue. That's a full webinar, where we talk about children. That's another huge stress I see with a lot of H-1Bs. The child is now 17. What are we going to do? So these things,
yes. Seema, maybe spend just 2 minutes on aging out. What does that mean, and why is that relevant? Because we do see a lot of that as well, and I think that would be helpful.
So in any petition, we did not, of course, cover that. When any individual files any petition, they cover their derivative beneficiaries. And derivative beneficiaries by USCIS definition is your immediate family, which would be your unit of your spouse and your children under the age of 21. So the USCIS defines every child as to be someone who is under the age of 21 who can file with their parents. So if the child is already 17 or 18 and your visa bulletin is showing that EB2 category, you have, say, the priority date of 2013. Now you go back to the visa bulletin and you see the priority date as April 2012 right now. Can you, in good faith, say that within next 3-4 years, your category will become current and your child will still be under 21, still be classified as your derivative, to be able to file adjustment of status with you is not a certainty. And that's where the parents start getting nervous, because now the child who's lived in the United States for, say, last 12, 13, 14 years with you, this is his country. Now, when you file your adjustment based on any other employment-based or family category, your child cannot file with you. You have to file adjustment of status before he or she turns 21 to be able to lock their age as your derivative beneficiary. So in that, due to this uncertainty, people want to file the investor petition, because if the child is 17, 18, 19, just under 21 also, say the child is going to become 21 in June and I file for you in May, your child is logged in, you are sure that your child will get permanent residency. And Sam, a lot of these H1s and L1s and any other visa, non-immigrant visa categories are here and want the best for their children. A lot of them tell me, we are not looking for permanent residency. We want to ensure that 2 of my kids or 3 of my kids or 1 of my children, whoever is with them, gets their permanent residency and can settle here. This is their country. They want to work and they want to live here. So yeah, that's a huge issue.
Got it. Okay. Yeah, that's really helpful. Okay, so I guess to wrap up, just to kind of shift back to that earlier question, why is now a compelling time, versus 2 or 3 years ago and versus 5 years in the future from now? Why is now kind of an opportune time for new EB-5 investment?
For me, the most important factor for now, of course, is the concurrent filing, whether you are doing consular processing, whether you're here on H1B. By consular processing, I mean whether you're outside and your kids are here. The concurrent filing has made it very, very attractive because of the immediate access to the work permit and the advance parole, the travel permissions. The number 2 is post-RIA government explaining, USCIS explaining their stand that the investors need to keep their investment for 2 years and create the 10 jobs, and then they can take their funds back. So in that situation, if a project is promising you 5 years of return of funds, which is a timeline in my humble opinion, that it generally takes 4 to 5 years for a project to fruitfully finish and return funds. The investors can now take their funds back. Pre-RIA, we had to wait until the removal of conditions application was filed. So it made a long wait and then another 2 years wait. And by the time they filed, the projects didn't know what to do and they started redeploying the funds. And then the individuals, say, waited for 7 years to get their funds back. Whereas now, you can be rest assured that within 4 to 5 years, your funds will come back to you. Lot of different provisions. In last few years, you've got the lawsuit where the government, the federal court has said that we can take loans, unsecured loans, and file for EB-5 investment. So a lot of different options. And then this regional center option is again good for 5 years. It came out in 2022 and it is going to end in 2026, 27. Until then, we can file with the regional centers. Find a good regional center, good project, get your funds ready and file. I think this is the right time. After that, we don't know. We don't know how the laws will change, whether we will have this concurrent filing. The visa numbers will be less and less. Whether we will have the 2-year, where you can take your funds back in 2 years, whether somebody files a lawsuit again and we have to again go back to secured taking loans against collateral. So a lot of little things that make EB-5 petitions very, very beneficial to investors at this point in time.
Got it. So I guess to quickly summarize, other than the investment amount now being higher than it was before 2022, all these other kind of new safety features, shorter investment time, adjustment of status ability, all that's, more advantageous now than it was before 2022. And then, looking to the future after 2027, the investment amount, likely is going to go up. Are, the rural and urban categories still going to be current? We don't know. Is adjustment of status still going to be possible? Is the investment period going to be longer than just 2 years? Maybe. So we've got a lot of unknowns, but a lot of the unknowns generally, it seems like, things will likely change after 2027, and more likely than not, they probably won't get better than it is now.
Definitely.
So,
of course, I do think that CIS has put a lot of scrutiny on the projects, so it's all for the benefit of the investor at this time.
Got it. Well, Seema, thank you for taking time to join us today and share your expertise. This was very, very helpful. And on the screen here, we've got your direct contact details. So for any investors who are watching this, please reach out to Seema directly with any questions related to the EB-5 immigration process, timing, source of funds documents, are you eligible? Could you adjust status? She's the expert on all of those questions, and anything related to any of the EB-5 projects that we discussed today or that we have listed on our website currently, please reach out to us and we'll be happy to chat with you more about the different projects that we have and which one could be a good fit for your particular situation and preferences. So anyway, thank you again, Seema. We appreciate your time today.
Thank you so much. Good talking to you. Take care, sir.